Okay, Your Honor. We have asked the question of the court whether or not the Federal Immigration and Control Act preempts the implementation of the measure in the ordinance. The specific question that we raised was whether or not fines are preempted by that legislation, because the statute does allow licensing and other similar laws to be implemented by state and local governments, but it doesn't it's not specific to fines. There is some dicta in the case law in the Federal Ninth Circuit that raises the question in our mind whether or not the fines would be preempted.
Well, it seems to restrict punitive measures, correct?
The case law, I don't know that it said punitive measures. It talks in some degree about the fact that the Arizona law was not a fine, and so it was not preempted, but it did not overtly state that fines were preempted.
But it seems pretty clear that the current ordinance provides for fines.
That's correct.
Any further insight that you would offer on the restriction of the amendment of the initiative?
It has been the county's position for as long as I've been here that the county governing body has equal legislative authority to the electors of the county. That being said, we don't take a position one way or another as to whether or not the county is authorized to necessarily amend the measure. Other than what we've stated in our petition, the county remains neutral, and it would simply like direction from the court on that.
Okay. Any additional comments or thoughts on the application of the ordinance within the jurisdiction of the municipalities in the county?
I can say that I've read all of the pleadings in the matter, and that issue seems to be very well briefed.
Okay. Thank you very much.
You're welcome. Thank you.
Why don't I go ahead and hear from whichever of the folks here from the ACLU wants to go ahead and raise their issues.
Thank you. We decided to break up the argument with the court's indulgence. I'd like to begin with the motion for summary judgment. And as the court knows, the parties have stipulated to a briefing schedule that provided that the motions would be filed on January 16th. Any responses would be filed on the 23rd. And in accordance with that briefing schedule, the plaintiffs filed a motion on the 19th of January that set forth several bases for striking down both the measure and the ordinance. They essentially fall into three categories. The first is that the measure and the ordinance conflict with state law. The second is the measure and the ordinance exceed the county's legislative powers. And the third is that the measure and the ordinance violate provisions of the federal and state constitutions. Now, in response to the motion for summary judgment, both the county defendants and the cities filed their own separate responses. But interestingly, neither one of them opposed the motion for summary judgment. And the county, when they filed their response, they said, and I'll quote, the county defendants do not concede or oppose the plaintiff's motion and are not submitting arguments either for or against the motions. Likewise, the city defendants said that they confine their response to the sole question of whether the cities consented to the passage of the measure and the ordinance within the municipalities. And even on that narrow question, they didn't take a position. So what we have here is an unopposed motion for summary judgment. Now, I think counsel for the county defendants offered some argument today. I think that's a 180-degree different position when they have their opportunity to oppose the motion, then they say we don't. I think it's not, they should be stopped from standing up in court here today and offering some, whatever opposition that they might have. I think that violates not only the spirit of the agreement that the parties had. You know, had they offered an opposition, we would have had a chance to prepare and offer comments in response or reply. But they took the position in a writing submitted to the court that they have no opposition, and I think they should be held to that. Commenting very briefly on the comments that were made by Mr. Lilly today, he said, number one, the takings arguments, the constitutional claims are not right because no property has been taken, but as made clear in our papers, this is a facial challenge to the ordinance and the measure. So it is right as a facial challenge. It's not an as-applied challenge. With respect to the other jurisdictional argument about land use, violation of land use, or conflict with state land use provisions, you're not being asked to make a land use decision that would be subject to LUBA's exclusive jurisdiction. The question that you're presented with is, do the measure and the ordinance conflict with the state land use law? That's not a land use decision, and that's an appropriate decision to be made by Your Honor and by this court. So, given that we have an unopposed motion for summary judgment where nobody has created any genuine issue of material fact, no one has taken any issue with the legal arguments that were made in the motion, we would ask that the court enter summary judgment in favor of the plaintiffs without any further proceedings. And we're happy to answer any questions the court might have or to elaborate on some of the arguments with Your Honor's indulgence.
I would appreciate some further elaboration. So I'm going to, at this time, withhold ruling on your motion for summary judgment.
Thank you, Your Honor. Ms. DeZono and Mr. Dale will split the substantive portion of the argument.
Okay, thank you.
Your Honor, I won't belabor how we got here today. I think we all know that Measure 5190 passed on November 4th with 57% of the vote, and very little money spent by the proponents on getting the initiative passed. The effect of that, however, is painstakingly clear. What you have is some language that was essentially cobbled together off of the internet using the Arizona statewide law, added in some punitive measures and some self-serving language regarding the drafter's personal occupation. And combined with the sweeping definitions included in the measure, this creates numerous conflicts with state law. It exceeds the legislative authority, the county, and renders it unconstitutional. Measure Ordinance 2008-6, passed on December 17th by the county, attempted to clean up some of the more egregious provisions of the measure. Unfortunately, it did not address the measure's fatal flaws. And so while we're talking about both legitimacy of both the ordinance and the measure, it's worth noting that the ordinance includes an automatic repealer, that the ordinance is automatically repealed if the measure is stricken for any reason. While this has been an emotional issue for many residents of the county, emotions have very little stake in our argument here today. The measure has so many errors and so many unreasonable provisions. It's so incomplete and yet at the same time overreaching that even if it were not unconstitutional, preempted by state law, as a matter of law, it cannot stand. Despite the broad legislative authority that a statutory county has, ordinances still may be affirmatively preempted by state law. And when you go back to the state land use planning system, Oregon has a renowned land use planning system that's based on it's having 19 statewide planning goals, a comprehensive plan, and the requirement that all county, city, local jurisdictions, planning and permitting decisions comply with those statewide goals and fit into the comprehensive